Good afternoon, everyone. Today, I will continue my lecture on the law number 18/2013 on the prevention and eradication of forest destruction. Before, I have explained what is forest crime and the categories of forest crimes under the law. In this presentation, I will focus on the procedure to handle the crimes stated in the law. With regard to the procedure, you can find it in Chapter 4. There are provisions that elaborate the procedure, whether it is re-emphasizes the provision in Criminal Procedural Code of Indonesia or KUHP, and it is also has different mandate with the code. The different regulations on the procedure presents the evidence that the law is a special criminal law. There are some indicators to say that the law is a special criminal law. One of the reasons is the define forest crime as an organized crime. It is stated in Article 11. As an organized crime, the crimes usually done by more than one person. It is organized with certain group that has structure in its organization. The crime is conducted in certain time by different persons, which they do not know who are the persons involved. They do their own part of the job as it is individual, but they do it at interest of the collective identity called as company. Because of this character, the law also regulates two kinds of criminal liability, that is individual and corporation. It means the law can charge individual for their crime. It also can charge the corporation for criminal conduct. This is different with the general criminal law that usually only recognize individual liability or responsibility. The provision on the criminal conduct and the punishments about the crimes done by corporation can be found in Chapter 10. The criminal procedure on this law is designed in order to solve some problematic situation as the forest crime is organized crimes. As stated in Article 3 of the aim of the law, that is for legal certainty and deterrence effect to people involved in forest destruction. This is by taking legal measures against the perpetrators of forest and around forest land and conducting traditional destruction directly, indirectly, or both by other means. It means there is a neat, unusual mechanism in handling the case. Therefore, law enforcers need to have a special procedure in order to process the case, both done by individual and corporation. It is also important to improving the capability and coordinations of law enforcers and relevant parties in the prevention and eradication of forest destruction. This law then discusses special procedure with regard to investigation, prosecution, and court examination. Now, I start to elaborate the special procedure with regard to preliminary investigation, and investigator. With regard to investigation, it can be done by both police officer and civil servant investigator, or we call that as PPNS. Here the law is re-emphasizing the criminal procedure stated in Criminal Procedural Code that both police and PPNS can conduct investigation of criminal case. Yet, the law provides more detailed authority of PPNS in conducting investigation, such as to follow up a report from society or informer, to make arrests, detention, search, and confiscation. The PPNS can ask for assistance from experts in investigating forest destruction criminal offenses. It can stop investigation in case of no evidence related to forest destruction criminal offenses. The investigator can conduct an audit in certain places, believed to keep evidence, financial accounts, records, and other documents, and seize materials and goods resulting from criminal offenses that can be used as evidence in forest destruction criminal offenses. It also encouraged the PPNS to do coordination with the police in order to conduct investigation. It also defined the authority of the investigators in order to communicate with bank, OJK, or other authority in order to block an account, to travel ban, to wanted list, and to suspend the suspect from their job or position. Furthermore, the specialty of the procedure can also be found in evidentiary system. The law states that evidence in case of forest crime consists of evidence stated in KUHAP, but in addition, it also states electronic information, electronic document, and map as evidence. It can be found in Article 37. Besides, this also regulates how to maintain the evidence with not only limited to the purpose of the proof the case, but it can be utilized for other purposes, such as it discussed in Article 45, 46, and 47. Evidence from conservation, as example, can be eliminated unless it is relevant to use for science purposes. Evidence from outside conservation can be utilized for social purposes. In addition, evidence might be auctioned and placed in state bank. The law has also specific regulation on evidence, such as the obligation for the investigators to have minutes in seizure evidence and to make report about it. To request the permission of use of evidence to the chief of district court is also part of their obligation. Based on the request, the chief of district court shall decide whether the permission is granted, including to use the evidence for other purposes. Now, I move to discuss about the acceleration of the process in law. The law also emphasizes that in handling forest crime, it shall be given to a priority over other cases to be brought to justice. This is by settling them as quickly as possible. Therefore, the law has very strict about the time frame in every step of handling the forest crime. For example, in investigation, indictment, court examination, and even in Supreme Court decision. The time frames are very different with one discussed in Criminal Procedural Code. The law has also has different principles, that is, the existence of in absentia principle. It means that the court still can continue to examine the case without the presence of the offender. Now, I want to discuss about fault and punishment that is stated in Article 82(1)(06). The law has very important principle in punishment, that is premium remedium, that said, compensation for losses caused by forest destruction does not eliminate the sentence of culprit. It means even though the offender has already provided compensation, the criminal procedure or process still need to be continued. With regard to the punishment, there are three levels of punishment. First, related to the punishment for individuals who commit crimes. The punishment is actually imprisonment and fine. The law provides minimum and maximum punishment. The minimum of imprisonment is 3 months till 20 years. With regard to company, the law actually provides administrative sanction that include force, fine, revoke the permit, and other sanctions. In addition, the law also provides special regulation for punishment for those who are involved in crimes. That is additional punishment, which is the heavier punishment of imprisonment and fine, but also there is administrative provision. To conclude this session, I want to say that the specific procedure in the anti-forest devastation law consists of, first, it related to principle, that is forest crime as a priority case, the premium remedium principle, in absentia principle, and individual and corporate liability. Second, related to the PPNS authority and other authority in investigators. Third, related to evidence and evidentiary system. Fourth, related to acceleration process in investigation, indictment, and examination. And the final one is related to punishment. I hope now you can have better understanding about the special criminal procedure in forest crime. Please see more detail in the instruction in ELISA. So stay healthy and success to your study.